Hi there. Welcome back to the step-by-step guide on how to write an A-level law essay. If you haven't seen my first video on statutory interpretation, I would recommend that you do so as it is an introductory video to my channel and how my video guides work. Before we begin, please note that this video guide will be most effective for you if you already have some basic knowledge of the relevant chapters that I will be discussing. As this is the second part of the video guide, I will be going through the whole written essay with you and then explain the workings as I go along. In case you haven't seen the first part of this video guide, I would like to encourage you to do so first so as to prepare you for the actual essay itself. I've inserted a link to the first part of the video in the description below. If you find this video guide useful, please like, share and subscribe to my channel, and don't forget to click on the bell button to get notifications of new videos as I will be making new video guides every week. With that said, let's get started with part 2 of video guide number 3. The question of the day reads, consider how delegated legislation has played an important role in the development of the law and critically assess the possibility of the practice also being a threat to democratic lawmaking in Parliament. To answer an examination question, we must first take note of two things. Which chapter is the question covering and what is the focus of the question? By first considering these two aspects of the question, we will know how to address the question appropriately. From the question, we can infer that this question covers the chapter Delegated Legislation. And the focus of the question concerns the importance of delegated legislation and the possibility of it being a threat to democratic lawmaking. As per usual, a complete essay needs to be structured properly. Therefore, our essay should include an introduction, relevant points, and finally a good conclusion which addresses the question. Before I begin going through the essay, I would like you to note that my answer is not the perfect essay answer, but it only serves as a guide for you so that you can get an idea on how to write your essay and score the highest mark possible for your effort. Incidentally, I may have also left out certain minor details from my content video, as whatever points that have been discussed earlier only serves as a guide for us to reach our end product, which is the essay. One more thing to note is that since, for examination purposes, the time limit for one essay answer is exactly 30 minutes, I will not have a lot of time to cover every single relevant detail, and the ideal word count for an excellent essay answer is between 800 to 1000 words per essay. Introduction. Man-made laws exist to regulate human activity, and these laws come from different sources, including laws made by way of delegated legislation. As delegated legislation is sanctioned by Parliament, it can be considered as written sources of laws. However, there is an argument that delegated legislation threatens democracy and democratic lawmaking. To consider the validity of this argument, we need to first discuss the purpose and practice of delegated legislation and how it actually affects the concept of democracy. It is very important for us to first define laws and sources of laws, especially written sources of laws, such as Acts of Parliament, which are very much related to delegated legislation. Though delegated legislation has been mentioned here, it is only mentioned briefly, because in the introductory stage of an essay, a quick preview of what is to come should suffice. As lawmaking and democracy are very controversial things, we should definitely discuss the workings of delegated legislation before we can actually make an informed decision on whether or not delegated legislation threatens democracy. Point 1, Body Paragraph 1. As the name implies, delegated legislation simply means that someone has delegated the authority of legislating laws to another. That someone is none other than Parliament, a collective body with the highest lawmaking authority in England. Delegated legislation is derived from its parent act, or enabling act, which prescribes its parameters and procedures for lawmaking. It is a canvas for which detailed laws can be inscribed upon by the people who have been charged by Parliament to do so in Parliament's stead. Some of the most common delegated legislations are orders in council made by the Queen and Privy Council, statutory instruments made by government ministers and government departments, and bylaws made by local authorities and public corporations. An important statutory instrument is the Police Codes of Practice that were made by the Lord Chancellor and the Secretary of State for Justice under the authority given by the Police and Criminal Evidence Act 1984. To develop the essay, the origins of a particular subject of a topic should first be addressed, and therefore, as according to the thesis statement in the introduction, we should now highlight the definition of delegated legislation and how it relates to Parliament. As part of the workings of delegated legislation, it is crucial that the types of delegated legislation should be discussed briefly, with at least one of the types explained further to illustrate how delegated legislation generally works. Point 1. Body Paragraph 2. There are many reasons for which delegated legislation is important in the development of the law. As Parliament is a collective body, it cannot deal with every specific detail of a particular law, and so therefore Parliament usually decides on the main provisions of a statute and then leave the specifics to someone else with more expertise on the matter to deal with it. This leaves Parliament with more time and resources to deal with other laws requiring more collective attention. Government ministers who have been delegated the power to legislate will be able to consult others who are either experts or have vested interest in the matter that is about to be made into law. Apart from that, the Legislative and Regulatory Reform Act 2006 has provided that government ministers with delegated powers are able to make or change any provision for laws if it so reduces the burden of Parliament's function as a legislative body. After discussing how it works, we should move to the reasons for delegated legislation and highlight some of the good points about its practice. This should definitely be directed at addressing the question on how delegated legislation plays an important role in the development of the law, since that is the first part of what the question requires us to focus on. It is from this paragraph onwards that we are actually addressing the question properly and going into the crux of the essay. It should be noted that this is only done after giving the essay a proper development or an origin story. Point 2. Body Paragraph 3. Although the Enabling Act is the primary control utilized by Parliament over delegated legislation, there are other ways for Parliament to make sure that delegated powers are regulated. One example would be the affirmative resolution, where Parliament will have the last say before it is officiated as an actual statute law. This method ensures that Parliament has control over the details of the law that has been made through delegated legislation. Other than Parliament, the judiciary also has authority over delegated legislation. This is only so if there is evidence to prove that, for example, a government minister has not followed the correct procedures provided for by the Enabling Act, such as seen in Aylesbury Mushroom Case 1972, where the courts held that the delegated legislation is ultra vires, i.e., that the minister has overstepped the powers granted by Parliament when he failed to follow proper procedure while developing the law. After addressing the important role of delegated legislation in the development of the law, we should move to discuss its regulation, as this is not just part of the workings of delegated legislation, but it is an important point to highlight so that we can critically evaluate the question on whether delegated legislation still poses a threat to democracy after knowing the fact that there are some controls over the practice of delegated legislation. And of course, with one example to illustrate each type of control would suffice for this essay answer. Point 3. Body Paragraph 4. To address the question on the threat to democracy, we should first understand the importance of democracy before we can decide if delegated legislation has threatened the concept of democratic lawmaking. Democracy is based off the idea that the development of laws should be influenced by the masses. Therefore, to allow an individual or a body of individuals who possibly is not even democratically elected to do the job of lawmaking by way of delegated legislation can be considered as an affront to the basic concept of democracy. This can be made worse if sub-delegation is also practiced within the government departments responsible for developing specific laws. Despite these issues, it should be emphasized that there are at least controlling bodies to regulate delegated legislation. However, both parliamentary and judicial controls are quite limited, and that controls will only be properly exerted when an abuse of power occurs and reported. With delegated legislation not being a frequently public affair like the laws that are rigorously made in Parliament, abuse of power and misapplication of power is rife. In this paragraph, we are addressing the second part of the question, and before we can do so, we should briefly discuss the concept of democracy and its importance first. Otherwise, we cannot emphasize how important it is. After explaining how delegated legislation can actually threaten democracy and democratic lawmaking because of the flaws of its practice, it would be good for us to at least make a brief contrasting point on how there are also controls to mitigate the threat to democracy. This is why it is important for us to introduce the fact that there are some controls over delegated legislation in point 2, so that now we can make a more informed and critical evaluation on the focus of the question regarding delegated legislation and its possible threat to democracy. Conclusion. As much as we need to delegate powers of legislation so that we can ease the burden of Parliament, such practices do not come without the problems of abuse which would ultimately lead to the idea that democracy is threatened. Therefore, I feel that there should be a more stringent check on delegated powers so that the practice can meaningfully supplement Parliament's role in lawmaking without the concern that democracy is being threatened. Instead, the practice of delegated legislation can be seen as an extension of Parliament's democratic will. The conclusion should briefly highlight some of the most important points of the essay which addresses the question properly. After much critical thought and discussion, a conclusion can be made and must coincide with our general view throughout the discussion. That is the end of the video guide. I hope it has helped you in your legal studies. Do check out part 1 of this video where I'll go through with you the contents of the answer to the question. I have linked the video in the description below. If you have any questions, comments, or any suggestion on what other topics you would like me to cover, please leave a comment on this video. And again, if you find this video guide useful, please like, share, and subscribe to my channel as I will be uploading new video guides on different topics every week. In addition to that, if you would like me to send you a copy of the whole essay in Microsoft Word form, please subscribe to my channel and then drop me an email requesting the document. Thank you.